In this lecture, we would like to discuss one of the most important topic, that is relating to election and representation. This topic, election and representation, is equally having its importance and gravity both in legal theory and also in political theory. So, regarding election, we would like to discuss certain theories of suffrage, such as natural rights theory, also the legal theory, and also the ethical theory, and the tribal theory, and lastly the feudal theory. So, as these theories bear real and vital importance in connection to both legal theory and political theory, so you would like to discuss this number of theories. So the first theory, that is natural rights theory. So according to this theory, the right to vote is a natural and inherent right of every citizen. It draws its support from the theory of social contract as an explanation of the origin of the state. The contract theory assumed a hypothetical state of nature where the people were supposed to be living in a free and equal life under the laws of nature. Since the state was created by the people through a contract among themselves, they have a natural right to take part in government. This right in this right to vote is thus an abstract right derived from the ancient laws of nature. So, as Professor Gatley points out, the fallacy in this theory results from confusing the ethical and the legal concept of law and rights. Only those possess the right to vote in the legal sense, upon whom the state has conferred such right by law. So, in response to the natural rights theory, now we would like to discuss the legal theory of suffrage. This theory treats suffrage not as a natural right but as a political right granted by the law of the state. Voting is a public function and the electorate is an organ of government. Hence, the composition and powers of the electorate are determined by law. It is not an ethical right but political expediency that decides who shall vote and what the voter shall do. And in response to legal theory of suffrage, now we would like to discuss the third important theory of suffrage, that is the ethical theory. This theory regards the right to vote as a means for the self-expression of the individual in political affairs by allowing the individual to associate himself with the government. Suffrage ensures the development of human personality. And now we would like to discuss the fourth theory associated with suffrage, that is the tribal theory. The conception of inclusive citizen developed among the early Greek, Roman, and Germanic people led to this theory of suffrage. Within a narrow citizen class, voting was supposed to be a part of the life of the community. It was a necessary attribute of membership of the state. Citizenship as a qualification for voting today is a survival of the tribal theory. And now we'll discuss the fifth important theory associated with the nature of the suffrage, and that is the feudal theory. According to this theory, developed in the latter part of the Middle Ages, the right to vote depends on a particular social status. In the past, it was usually associated with the ownership of land. The modern emphasis in some states on property qualification may be said to be a relic of the feudal theory. So, of all the theories examined above, the feudal theory and the legal theory tend to limit the right to vote by imposing some restriction. The present tendency, however, is to ensure widest possible extension of suffrage, which is supported by the tribal theory, the natural rights theory, and the ethical theory. Still, as Professor Garner points out, the view which practically all writers on political science and in legal science adopted today in regard to the nature of the suffrage is that it is an office or function which is conferred by the state upon only such persons as are believed to be most capable of exercising it for the public good, and not a natural right which belongs without distinction to all citizens of the state. And this was, as Professor Gardner explains in his work Political Science and Government. So opinions, however, differ as to whether the exercise of voting should be regarded as a moral duty or as a legal obligation. It may well be argued that for an accurate representation of the will of the electorate, voting should be made compulsory. Contrarily, if the suffrage is used as a right or a privilege, the individual may have the discretion to exercise it or not as he deems fit. In practice, however, compulsory voting is in operation in only a few states like Belgium, Romania, Argentina, and some of the Swiss cantons. Compulsory voting It is generally believed lowers political life, produces anti governmental feelings, and tends to create political corruption. As after all, a man has a right not to use a right and is not obliged to be interested in political issues. He may be short sighted and foolish and cannot complain if things don't go according to his wishes. But voting is his own business. That is of the essence of democratic freedom. So, in this lecture, we have completed the theories of suffrage as associated in election and representation as part of both legal theory and political theory. And in our upcoming lecture, we would like to discuss universal suffrage.